Hello, Lena Jacobs. How are you? Welcome, everybody. I'm just going to let a few people get in, and then we will start. It's not going to be a very long live today, you guys. I just want to bring you the updates on the Vallow Daybell case. Hello, Gulf Coast girl. Nice to see you. I'm doing very well, Lena. Thank you for asking. I hope you are. Very cold here today. I was hoping most of the snow would be gone, but it's still lingering. Hello, Muskoka Gardening Unit. How are you? So the circus is continuing, you guys. I had just said, I think in my last live that, or on Sunday, one of the two lives on Sunday, that we hadn't heard much from the Vallow Daybell case, that I thought finally everybody had got their crap together and stopped all this childish games. But hello, Missy. Thank you for being here. It's not going to be a very long one. I'm just going to go over the new filings in the Daybell case, Vallow Daybell. Like I was saying, I thought, you know, people had came to their senses and was going to stop wasting the court's time and stuff on frivolous things, but it doesn't seem like that is going to happen. They gave us about a week's break, and now they've gone at it again. So what I'm going to do, you guys, is I'm going to go over this quickly so I don't take up too much of your time. So we'll get going on it. Okay, so this was filed 2 days ago, and Rob Wood filed this. This one's pretty short. And then Mark Means fires back. So it's like, and in the way that he does things, he's staying true to his course of actions. I'm telling you, he's just gone off the rails again. So we'll go over this one that Rob Wood filed. He's just trying to cover all bases here because he doesn't want any more delays by the looks of it. So he is trying to cover every base regarding discovery and disclosure. So he says, comes now the state of Idaho by and through the Madison County Prosecuting Attorney's Office and pursuant to Idaho Criminal Rule 16, hereby notifies the defendant of the following. Documents and tangible objects. Defense counsel can inspect and copy or photograph the items or material described in Idaho Criminal Rule 16b-4 by simply making prior arrangements with the Madison County Prosecutor's Office or law enforcement agency holding such items or evidence. In addition to the above, the state may also utilize the following as evidence at trial, all of which has either previously been provided or is attached hereto. Please see addendum E. So there's a third supplementary discovery disclosure that was, I guess, sent to Rob Wood. So he basically, from John Pryor and Mark Means, so basically he filed back and said, anything you want, you know, you can come and get at the prosecutor's office or whatever. So it's like, he's kind of trying to just cover all his bases as to say, we've never said they couldn't have it. We've told them it's here, come and get it type thing. So then Mark Means files this the next day. Okay, so the state of Idaho versus Lori Daybell and Chad Daybell. So you see here, you guys, they have changed her name as requested to Daybell. Oops, never mind. I'm not going to highlight it. You see what I'm saying right over here. She put up a big stink about her saying they were using Vallow as her name. I guess it was upsetting her a bit. Anyway, so everything that he's including, this is going to be the most lengthy part. Declared motion to oppose use of DNA. Declared motion to preserve DNA samples. Declared motion for photographic recordings of serology samples and other visual tests. Declared motion to review lab records. And a declared motion for instructions to prosecutor regarding improper ex parte communications with the court. So he's complaining because here he's not asking for any kind of motion, Rob Wood. He's just wanting to put this on the record and in the continuing record that he is not objecting to anything that the defense wants, that they are more than welcome to, come and see it or go and get the evidence or whatever. So it's like Rob Wood is a little peeved off now that Rob Wood didn't do this as by ways of a motion. He just put it into the continuing record. And it's like, you dum-dum, and I'm going to call Mark Means a dum-dum. He's putting it into the record as to save court time, legal fees all around, stop wasting court time. He put it into the record. He made you aware of that. He put it into the record and basically telling you anything you want, we don't have a problem giving it to you. Come and get it. Okay. But that wasn't good enough for Mr. Means. He's wanting a motion for instructions to the prosecutor regarding improper ex parte, which means he did this without the other lawyers being present. So ex parte communications, and this gets interesting, you guys, because he complains about Rob Wood calling him or emailing him at midnight. It's just ridiculous. So regarding improper ex parte communications with the court. So let's go through this. Comes now defendant Lori Daybell by and through her attorney, Mark Means, of Mark Means Law Office, and move this court as follows. Defendant hereby joins in the motion filed by defendant Mr. Chad Daybell by his attorney, John Pryor. So John Pryor has filed a motion too. I just don't have it yet. Attached is a correct copy of the midnight correspondence to counsel from prosecutor in this matter, as well as a correct copy of the email sent from prosecutor Wood, which was CC, carbon copied, to the court directly. Counsel has previously requested that this prosecutor cease all CC information with the court, as that is improper, is a form of ex parte communications and the like. Like he's going off the rails here. The continual improper communication places this court in an awkward situation unnecessarily by the said prosecutor. It appears the prosecutor is attempting a backdoor communications method to potentially protect himself from a Brady violation finding of this court based on the prosecutor's continual refusal to provide full and complete discovery responses. So he's saying he's trying to backdoor him by just putting this into the continuing record instead of doing this through a motion. It's like, what? All he's trying to tell you guys that anything you need, you can have. This direct improper ex parte communications are potentially making this court an unnecessary witness in future litigation. Defendant Lori Daybell hereby requests, as set out by Mr. Pryor, all relief sought in this motion and an order of this court of instruction to counsel to seize this unnecessary ex parte communication. Certificate of service. So what he is attached. He has attached. Okay, this is the letter from Rob Wood to them, saying he got this at midnight or some crazy thing. And this is what it is. Madison County Office of the Prosecuting Attorney. Okay. To John Pryor, State of Idaho versus Chad Daybell. Mr. Pryor, I am including Judge Boyce and Mr. Means on this correspondence because I'm following up on a matter that you brought up during our recent status conference on April 7th. You mentioned at the conference that you estimate you are missing 30 items in discovery from the state. To date, I have not received any specific information from you regarding what you are missing in the discovery from the state. You did send 2 letters regarding discovery in the recent months, and we responded to those requests before our recent status conference. Okay, Lena Jacobs sees Means and Pryor are trying to kill Woods with 1,000 paper cuts. Yep, exactly. And Christine says, oh my gosh, the man's a fool. Jenny Lynn says, Lori played a lot of legal games during the time when Joe Ryan wanted custody of Tylee. She and lawyer went after the counselors, Tom Moore. Yeah, it's just, they're continuing, right? So, I would note that all times requested in those letters had already been provided to you and have been provided to you, other than the Tammy Daybell autopsy report, which the Fremont County prosecutor has not and will not provide to my office. You did mention at the hearing that you have not had the opportunity to review everything that we sent to you. Needless to say, we were surprised by your statement in court that you were missing such a large number of items. According to our records, we believe we have provided you with every document in our possession that you are entitled to under the law. My paralegal is preparing a small supplemental disclosure of items we have just recently received, and it will be sent to you and Mr. Means no later than next week. However, if you believe otherwise, please provide me with a list of the specific information that you are missing and legally entitled to in this case so that I can address your concerns. Now, this is exactly what should be done between the defense and the prosecutor. When you need something, you want something, you send the prosecutor or the defense a letter like this instead of bringing everything to court. I don't know what Mr. Means is not understanding about that. Now, the only time you bring a motion for disclosure to court on a motion for disclosure is when you have tried things like this and you're not getting the information you're requesting. So it's like, look at, you know, Rob Wood did this the way it should have been done. Okay. So this is what Mark Means now sent to Mr. Wood. Now, Mark Means is doing to Mr. Wood exactly what he's accusing Mr. Wood of doing wrong. I join Mr. Pryor's objection regarding consuming all remaining DNA samples testing. If you proceed, I will seek, as Mr. Pryor stated, all remedies available for my client for this unprecedented attempt to unconstitutionally handicap the defense in this case by your suggested actions. So I'm going to go, before I get off this live, I will go and check one more time and see if it's there yet, where Mr. Pryor put an objection regarding consuming all remaining DNA samples for testing. As a formal notice, I am requesting, as if discovery requests were not sufficient, that all reports, records, information, notes, etc. be provided immediately regarding this matter and any other matter or issue in regard to this case. Your office continually appears to have intentionally and wrongfully withheld this discoverable information and documents to date for unreasonable amounts of time. Please confirm through writing that you will comply with these requests today. Email would be appropriate, or I will seek an injunctive relief as well as other remedial measures readily available. So let me just go and check you guys again. And see if it is there yet. If it is, I will bring it up. I'm checking right now. Oh, okay, I've got it. I think right here. Okay, let me just get this open, you guys, and see what it is. Okay. I do have it now. Okay, so let me share my screen. Before I do that, let me just see the comments. Just roll with it. Laugh out loud, your circus thumbnail thingy. Yeah, I've been calling this a circus for a little while. Most of the subscribers have, you know, seen that. I started calling it a circus just a little while back because it was like a circus. Nobody knew what they were doing. The right hand didn't know what the left hand was doing with a lot of things. They were wasting court's time. It was motion after motion, motions on top of motions on top of motions. It was just the judge had no control of his courtroom. It was like a three-ring circus. Tina says, I might take a banana. Christy says they're just trying to stir up doubts in the, about the court case, probably trying to set up for a mistrial. Could very well be, but this pretrial stuff with the motions would not have anything to do with any kind of mistrial unless they don't get all the information and then it's proven in court. Yeah, I say this all the time, Christy, not my circus, not my monkeys. Tina says, Christine, perhaps he forgot to bring his reading glasses. Okay, so let me get sharing this for you guys. What did I do? What did I do? What did I do? You guys still hear me? If you guys can still hear me, press 1, please. Okay, because my screen is buffering for some reason. I don't know why. It says it's not responding. Okay, so you guys can still hear me. Okay, well, I don't know why this screen sharing thing is not responding, but it's stuck on my screen, so I can't do anything about it. So as long as you guys can still hear me, I will read through this. Okay, what is going on here? And if it comes back or whatever it's doing here, I will bring it up. So as long as you guys can hear me. Okay, so it says in the District Court, the 7th Judicial District. Okay, so this is John Pryor filing this. Motion to oppose use of and motion to preserve DNA samples, motion for photographic recording samples and other visual tests, motion to review lab results. And it says, comes now John Pryor, counsel for the defendant, and hereby respectfully requests the court set an expedited hearing for defendant Chad Daybell's motion to oppose use and motion to preserve DNA samples, motion for photographic recording of all samples and other visual tests, motion to review all lab records, processing procedures, policy procedures, and reports of the state lab or other lab performing testing on the samples related to this case. That on April 21st, the special prosecutor, Rob Wood, sent correspondence to defense counsel that he intends to perform DNA testing on samples obtained by law enforcement. On April 21st, he submitted to my office notice that there is additional discovery not yet provided to the defense counsel that would be forthcoming. This additional discovery included, but was not limited to, some DNA testing that had not yet been provided to the defense. He notified my office by such correspondence that additional DNA testing would completely consume the remaining DNA evidence obtained by law enforcement. Ooh. So law enforcement is testing more things that they have gotten, and they're saying that these tests that they want to do are going to completely consume the remaining DNA evidence obtained by law enforcement, which means if the defendants want to send the evidence off for their own DNA testing, nothing is going to be available for them to do that with, because the additional DNA testing that law enforcement wants to do is going to completely consume the remaining DNA evidence that they obtained. So this would preclude the defense from seeking independent testing by their own expert. The defendant is requesting the following: that the court order the state not to pursue any testing on remaining DNA samples until such time as the defense can obtain half of all samples, to allow defense to perform their own DNA testing of all samples. That the court order the state to provide all record, reports, documentation relating to the testing that has been performed to date. That the court order the state to allow defendant's DNA expert to go directly to any lab testing such samples to review, copy, photograph, and document any and all process tests, procedures, and testing procedures that will be performed on the additional samples and have been performed to date. To provide to the defense any and all other evidence related to DNA testing in this case. So do you guys think that he is just trying to stop LE from doing any more testing? Do you think that they actually want to do their own DNA testing? What do you guys think? Because I'm under, what I think is, if they wanted to do DNA testing, the defense, which means John Pryor and Mark Means, that they would have already requested samples, don't you think? What do you guys think? Tell me in the comments before I go on. What do you guys think about that? Hey, Daz. That's okay. We're almost done, so I know you were very busy. Can you guys still hear me? Okay, so yes, my screen is still frozen, you guys. I don't know what's going on. I was trying to share this with you, but it froze up my screen, so I don't know what's going on, but I want to get this out to you. So, okay, so we're going to continue. He's also asking that the court order the testing agency performing any test to photograph, record, and document any serology, microscopy, or any other visual test performed or to be performed on any DNA sample related to this case. The state be ordered to allow the defendant's DNA expert to examine all qualification evidence, extraction evidence used and documented by the state's lab, that the court set an expedited hearing on this matter to avoid the state moving on its intention to consume all DNA evidence prior to defense having the opportunity to even review such evidence. And it was signed John Pryor. I can't even refresh my page, you guys. So I don't know why that's doing that, but at least I can still see your comments. Oh, Tina, I can't even put up any of your comments or anything, you guys. It's frozen on my screen. So, but I did want to get that out to you guys, and I'm going to end the broadcast. Well, let me see if I can exit this and come back. If you guys lose me, if this ends the broadcast, I'm sorry, but I wanted to get this out to you. But let me just exit from here and come back in and see if that fixes it. I got myself, see, that's what happened. I got myself there twice. Okay, so now that I've got you back, do you guys want me to bring that up so you guys can see it? Now that I am back, I can bring it all up if you would like to go over it too. I should actually put it there in case you guys want to. Okay, so let me try and share screen. Okay, screen one. Yay! Okay, so here it is, you guys. This is what I was trying to bring up, and for some reason, you guys on my second screen froze up and I couldn't bring this up. So here it is. So this is what John Pryor, you can see up here, John Pryor, what he filed. Okay, and he wants this motion. Like I've read through this with you. Okay, so he wants a motion and he wants an expedited hearing, which means I'm getting messages upon messages. Des, I'm still seeing them on StreamYard. You guys are looking at this on... That's weird. I don't know why. We ran into this last night on the live too. Every time on Doug's channel, every time I posted a link, it would stay there for a couple seconds and then it would disappear. Google moderators or whatever, it says Google moderators are removing it. So is it still deleting your messages on, because right now I'm on the StreamYard, in the StreamYard part, and I can see them still on my screen. Like I'm not on YouTube itself, I'm in StreamYards and it's streaming to my YouTube. So I don't know what's going on, but it's, by the sounds of it, it's doing it on everybody's channel. So if you guys want any of those links that Des just posted, they will be in the description area of my video. Des, is the super chat option in that there? Or is that gone too? Okay, so that's happening right on YouTube. That's because in my StreamYard software I got open right now, I can still see all your links on in the chat, in the live replay. Like in the live chat, I can see it. All your links. Okay, so the super chat options and everything are there. Okay, so I don't know what's going on, you guys, because with the links being removed, I have no idea. So I'm gonna have to watch and see if the links stay in the live chat replay when this is replayed. Well, thank you, sis. Oh, thank you, Jade Patrol. I appreciate you guys so much. Oh, thank you, you guys. Yeah, there's something wrong. There's something wrong. So thank you, Des, my sister. But she's saying it won't let her post in the super chats either, whereas before you could. Thank you, Jade Patrol. I appreciate you. Thank you, Missy. I appreciate you. I don't know what is going on, you guys. With yes, I really appreciate the super chats and the super stickers. Okay, so let's go on through this. Okay, so here are here's what I just read to you. I'm going to put it in here for you guys. I'm not going to reread it all again, but just so it's here so you guys can pause it and read it for yourself if you want. But he wants an expedited hearing. Okay, and you ask for that generally when there's something of extreme importance like this. If he believes that, as he says down here, that I'm just going to try and highlight it. Like, let's hope this works for me this time. And it doesn't look like it's going to. No, it's not. I don't know why, but he's saying that it's going to completely consume the remaining DNA evidence that law enforcement has collected. Okay, so he's a little upset, as I would be too, if I wanted to have my own expert do testing on DNA evidence. But what is surprising to me is that they haven't asked for it for their own testing up till now. I don't think they've got the money to do their own testing. So I believe that is why, and you guys can let me know what you think below. Oh, that's okay, Christy. I think he's just doing this because he doesn't want the prosecution doing any more testing. Okay? Because to me, if this was a case I was working on back in the day, we would have already asked to do our own DNA testing at this far in. So I think that this is, and because he wants copies of all the DNA testing that have been done by law enforcement, this is telling me he's just trying to stop them from being able to do any further testing. Okay, so like I said, I will scroll through this so you guys can see it later if you want to pause it and read it on your own. But I did go over all this and read it out before I could get it up on the screen. So this is what he is asking for in this expedited hearing. He wants the court to order the testing agency performing any test to photograph, record, document of anything done, okay? And he wants the court to set an expedited hearing on this matter to avoid the state moving on its intention to consume all DNA evidence prior to the defense having the opportunity to even review such evidence. So that's basically what it said. So it's all here, you guys. If you do want to read it yourself, I did read it out loud because I couldn't get it up on the screen at first. It is here if you want to pause it and read it. Okay, I'm going to stop screen sharing. Bring this back over to my huge screen so I can better see what you guys are saying. Well, thank you, Drama. Thank you again, Missy. Thank you, Drama must remain on stage. Nice to see you here. Glad you could make it. I appreciate your support, everybody. Now, I'm going to let you guys know, too, while we're here, I'm shooting for Tuesday, Wednesday for part 2 of my series on the Kendrick Johnson case. Hopefully, I will be able to bring Doug in for some of that, too. Maybe I'll do one on Tuesday and then bring him in on Wednesday so we can kind of go over what came out and get his take on it, and you guys can ask him questions and whatnot. I just don't think it's fair to keep him in limbo in the background as I'm going over everything. So what I might do, I haven't decided, I'll talk to him. I don't know if I will just get the information out there first and then have another live with him to go over what I brought out. Wednesday is picture day for Bailey. What time? Yeah, see, I can see Missy's link that she just put, direct link to memberships. I can see her links. I can see back, Des, all your links that you put before. For memberships, for the support shirts and stuff like that. I can see them all in my actual, because I'm on the Streamyard. it's streaming to YouTube. So I don't know if there's something going on with in between what I'm seeing here on the StreamYard platform. There's something going on as it's being sent to YouTube. See, there's a little bit of a delay between what I'm doing and when it gets to YouTube. So I think there's something, there's a glitch or something in between StreamYard and it's sending to YouTube. Yeah, let me know because, or I can do my live Tuesday morning and then bring in Doug Tuesday afternoon. We'll see how that's going to work. I don't know because I've got a lot. Yeah, I'm going to show you, Des. I'm going to scroll back here for a minute. You guys just give me a second. I'm going to show you what I'm seeing, Des. See, I'm on the StreamYard platform. You guys are on the YouTube platform. So I don't know why the links aren't showing up on the YouTube platform from StreamYard. But there's a glitch in between StreamYard sending it out and YouTube getting it. There's some kind of glitch there. Yeah, it happened when I tried to post links in Doug's live last night too. It kept deleting my, and it says Google moderators or something. Yeah, they don't delay or stop their, yeah, good point there, Christine. Christine says they don't delay or stop their ads though. YouTube drives you nuts sometimes. I don't know if it's a YouTube problem or a StreamYard problem, because I believe Doug was using StreamYard last night too. It could be a glitch because I'm not on YouTube right now. I'm in StreamYard. And whatever I do in my StreamYard, it's being streamed to YouTube. Like you can click, it's hard to explain. When I set up this live in StreamYards, it asks me where I want to stream it to, and I click YouTube. So I don't see the YouTube side of this at all when I'm on my StreamYard, but I know it's being sent to YouTube because you guys are in here, right? So it's somewhere, there's a glitch somewhere between what's happening here on StreamYard and as it's getting to YouTube. I don't know where the glitch is, if it's StreamYard or if it's YouTube, but there's a glitch somewhere. Okay, Des. But yeah, it happened. Hey, G-Dog. We just finished going through all the documents, but this will be on my channel under videos. If you want to go back and see all the documents. Des says, each message we post with links in them says message deleted by Google moderator team. Yeah, like that is, I think, Des, I'm going to have to go into my settings too, because I think it was with the new YouTube update. I don't know. It's ever since then. So I might, well, no, because I'm on my computer. I don't know. I don't know what's going on, but I'm going to have to inquire about it. So, and I'm not the only one having that problem, so. Okay, so like I was saying, you guys, I'll let you guys know Monday morning at the latest. I'll make a post as to how I'm going to do this. If I just go over all the information and then do a second segment, like a part 2A, and bring Doug into it, so then we can go over everything that's come out, and maybe as he's watching it, he can write down anything that, you know, questions or whatever that may be there, or you guys can write down your questions regarding it, and we'll see if I can't answer it, if Doug will be there to see if he can answer. Okay, so let me, yeah, see, I've got, so there's a direct link to memberships. Like I said, you guys, if you can't click on these links before they disappear, they will be in the description section underneath this video. All my links are there for my email, for memberships, for PayPal, for my Bonfire store. So I'm just replying to Des here. Just give me a second, you guys. Okay, Missy, you take care. Love you, girl. So, and I will be putting links, you guys, up in a post to last night's live. I will do that in a separate post on my channel. So if you guys want to go and check that out, you can. Okay, so I'm going to end this, you guys, and I didn't want to take up too much of your time, but I will put a post on Monday to let you guys know when part 2 of the Kendrick Johnson stuff is going to be starting. I'm going to put a post when I'm done this live regarding the session from last night with Des, where she did her spirit box session. I will put that post up as soon as I'm done this live broadcast, and it will be in my comments. Okay, so I'm going to let you guys go for now. Thank you for joining. Thank you for all your support. Thank you for spending almost an hour with me going over these, and I will keep my eye out for anything else. So until next time, you guys, please take care of yourselves and please stay safe. Bye-bye for now.